What it says is, if a person was initially put into immigration court proceedings through the expedited removal process, 235B1 of the Immigration Nationality Act, process through the border, right? They were given a credible fear interview, all right? In my case, my client was given a credible fear interview, passed the credible fear interview, and then was paroled out of custody, right? If you're paroled out by ICE, they allow you into the United States. They allow you to be released from custody. But what happens if later they detain you? They relinquish, they undo their parole because there's a new political administration in the House. They change their mind. Nope, we're not going to release you anymore. We're going to detain you again. Well, are you eligible for a bond hearing or aren't you? What Matter of Q. Lee says is it takes you back because you were in expedited removal proceedings, which normally are not eligible for bond, right? Now they have re-detained you. You're now in expedited removal. For my client, they're not in expedited removal proceedings. They're now in asylum proceedings, but they have to fight their case detained. All right, and that is what happened, and that's what Matter of Q. Lee means, right? So a lot more people are subject to detention who in the past had good arguments to not be subject to detention. And so, for a lot of these people, they have to wait at least 6 months then before they can argue detention, before they can argue that their detention is quote unquote prolonged and request a bond hearing based on that.